screaming, I think.
Are you ready, Anu?
Go ahead, Sridevi.
Okay. A very good evening and a very warm welcome to everyone. Yes, a summer warm welcome to everyone. My name is Sridevi Jagallamudi, President of Telugu Finance Society. TFAS is a New Jersey-based Telugu organization with more than 35 years of history. Every 2 years, a new committee gets elected. This is our second virtual event after we are recently got elected. So I want to introduce my team before we go into the session. Then let's see, Bindu Elementally, Vice President, Usha Darsipudi, Secretary, Jyoti Gandhi, Treasurer, Anuradha Para, Events Chair, Anuradha Dasari, IT and Web Chair, Yashoda Dasika, Youth Chair,
Namaste, Andy.
Srinivas Cheru, Membership Chair,
Hi there.
Ravi Annadanam, Community Chair. This is our executive committee. So before we start the session, I just wanted to have some usually house rules, but this is our virtual Zoom session. So I would say Zoom rules. So I want to, we are like our IT chair will keeping everybody on mute. If you are not talking, please keep yourself unmute so that it won't be like disturbing others. And when the presenter is presenting, it will be clear also. And also, we did get the, and thank you for the people who registered earlier, and we got the questions, and you had some questions posted during the registration, and thank you for that. And you were all your questions will be answered by Akshat. And if during the session, if you have any questions, please try to use that Zoom chat so that to post your question. One of us, our team members, will take care of that. We will get that question to Akshat to answer it. So hoping that we will be wrapping up this session like an hour and a half, so depending on it, Akshat, the time also. So I'm just to keep it like 1 hour to 1.5, but we might finish it 1 hour. So we'll see how it goes once we start it. So as I said, our today's guest is Akshat Tiwari, and I would like our team member Ravi Annadanam to introduce Akshat. Then we'll take it from there.
Thank you, Sridevi Garu. Great. Good afternoon, Akshat, to you this Sunday. Thank you very much, firstly, for joining the TFAS Immigration webinar today. It's a pleasure to see you again. Firstly, Akshat Tiwari is a senior attorney from the law offices of Kamlesh Tiwari. He has over 15 years of experience in advising individuals and companies on employment-based immigration, employment law, and corporate law issues in the United States. He is authorized to practice immigration law in all the 50 states of the USA and is a member of the bars of multiple federal courts and the United States Supreme Court. He has undergraduate and graduate degrees from Columbia University and a law degree from Fordham University. Again, thank you, Akshat, for joining us today and agreeing to answer questions in a live session from TFAS members and registrants. Sridevi Garu, back to you. Thank you.
Thank you, Ravi. It's a nice introduction. Welcome again, Akshat. As you say, like as we planned it, you can go ahead and present what you would like to share with our audience. After that, once we will questionnaire session. So one of our team member, each of our team member will be asking the question. So you have time to answer each question. If anything, we can circle back then. Okay. At the same time, as we get the questions in the Zoom chat, we will be asking those questions. So we'll make this as an interactive session. It's not like a serious education session or you got everybody. So let's have a informative and interactive session. Back to you, Akshat. It's all yours.
Okay, sure. Can you hear me first of all?
Yep.
Okay. All right, Ravi and Sridevi and the rest of the executive board at TFAS, thank you for having me on this call. As you all know, there's a lot going on with immigration these days. A lot of members of our Indian community are very concerned about what's happening. And there's also some misinformation and generally fears about what the law is. So what I thought I would do, maybe 15, 20 minutes, quickly summarize all of the major changes that have been happening in the last couple of months, and there's been a lot. And I'll give a very concise but complete summary of what you need to know. Any of these topics, we could talk about hours for any of these topics that I'm going to talk about, but I'm just going to give you the quick summary, basically what you need to know. And I'll do it chronologically in terms of what's been happening in the news most recently. So the first thing that most recently happened was, all right, so whenever I give a talk, I always make the distinction between status and presence, lawful presence. So you could be in the country without status, and most of the time, if you're in the country without status, you're also in the country without lawful presence. Now, the two are similar, but not the same. So it's possible, for instance, to be in the country without status, but not unlawfully present. And when one applies, the other applies. It's a little bit complicated. But generally, if USCIS or an immigration judge has found you to be out of status, at that point, you start accruing unlawful presence. And why does that matter? Well, unlawful presence, out of status means out of status. People know what that means, but unlawful presence has an additional penalty that can apply. So if you're unlawfully present for 6 months, you get barred from coming back into the US in the future for 3 years. And if you have 1 year of unlawful presence, then you're barred from coming back into the country for 1 year. Oh, sorry, for 10 years. So that's a significant penalty. So there's a lot of people that, for instance, say your H-1 extension got denied, now you're out of status, you're accruing unlawful presence. It's not good to be out of status for any number of days. Generally, the more number of days you're out of status, the harder it is to, say, apply for a visa when you go for stamping. But if you do accrue 6 months of unlawful presence, you get a 3-year bar, right? And this applies to all immigration classes, right? You want to be both maintaining status, and generally, if you are, then you're not having unlawful presence. Why does that matter? Well, in 2018, USCIS, as part of its general attempt to make immigration harder for people in the US, what it did is it came out with a memo that said for students, FJ and M students, if immigration finds you to be out of status, they can find you out of status not just effective today, but retroactively. So they can say, oh, you're on a CPT program, you've been on CPT or OPT for more than 12 months. We're going to say you've been out of status for the last 2 years, and also accruing unlawful presence for the last 2 years, which means immediately you're subject to the 10-year bar. Now, this is a very extreme kind of result, and people didn't like it, and there are a number of lawsuits challenging it. And the latest news that I'd like to report here is that basically earlier in the year, USCIS lost at the district court level. So basically this memo that said that unlawful presence can be applied for F, J, and M students retroactively was put on hold. It was enjoined by a district court. And this week, USCIS announced that they would not be appealing that. So the rule goes back to the way it's always been, which means if you're on F, J, or M status, and USCIS finds that you're out of status, your unlawful presence starts from that day. It's not retroactive. So, you have to obviously leave the country or get your status fixed in some way, but you have 6 months basically to do that before the 3-year bar kicks in. There's no retroactive finding of unlawful presence, which puts, which if that law were in place, it would put people in a very difficult situation, right? Retroactively, there's nothing you can do to fix that. So that's one good result that happened this week. The other thing that happened recently, also very good, is that the public charge rule has been put on hold by a district court. So immigration has been losing a lot of court cases, generally because the more unreasonable positions they take, courts are kind of a check on that. So they stop them from taking those unreasonable positions in some cases. So the public charge rule is one of those examples. So what's the public charge rule? Well, for over 100 years, immigration has said, if you're very poor and you're at risk of becoming on welfare, we're not going to let you in. Right? We're not going to get you a green card. We're not going to let you in on an AHF, any other status. It's very loosely defined standard, or it has been for a long time. And the threshold was also pretty low. Okay, so as long as you had, some basis of support, someone here that could, even if you're old, you're without a job, if you have someone here that can support you, public charge would usually not be an issue. But as we all know, the Trump administration is famously very anti-immigrant, and they've had a kind of an assault on immigrants and immigration in various areas, and public charge was one of them. So they came out with a rule last year that with a much greatly expanded definition of public charge. So if you're applying for anything really, especially adjustment of status, green card, even FJM, some of these non-immigrant visas, they would be asking you, either have you in the past used government assistance, or are you likely to need government assistance? And in the case of the 485 green card application, it's a 20-page questionnaire that's asking you for your credit history, your school, your education, any kind of trainings, any certifications you have, whether you've had any benefits, any government benefits, Social Security, Medicare, even Obamacare. They're asked about that, even though that's not a factor. It didn't go into the factor in public charge, but they still ask about that. They ask about your health insurance. So it's a very rigorous and onerous standard that they established, again, with the reason of kind of dissuading people from applying, right? They're putting fear in people's minds. Okay, maybe my application won't get approved. Maybe I shouldn't bother applying. Maybe I shouldn't bother coming to the US. That's kind of the motivation behind it. And a court recently, the Southern District, which is a very progressive court generally. Some of you that follow the news may know that the Southern District has been actually pursuing Trump for some criminal charges. So they're kind of anti-immigrant, they're anti-government in some ways, in the sense that they're fighting for, I guess, reasonableness in our administration. But in any case, the Southern District put the public charge rule on hold. Okay, so that's not permanent. And there's a couple of other cases that are pending also in other districts. But for now, the public charge rule is on hold, which is good because it reduces the amount of time and expense that anyone that's applying for, especially a green card, has to deal with. The other thing that's coming up is USCIS, because they've been making immigration harder, so there's more RFEs. Before there were not in-person interviews for employment-based green cards, now there are. They're taking longer for applications. They're just making their work more and more difficult. They have been through these more stringent and onerous adjudications. And as a result, they have limited manpower. They can't do that and still maintain their budget. So because of all these policies, they've been overextending themselves the last couple of years, with RFEs and all these other things. They now have a severe budget shortfall. It's 1.2 billion. That's what they claim. Now there's some doubt about whether that number is accurate, whether this is, again, just a political ploy to shut down the immigration system. But in any case, that's what they've requested. They requested 1.2 billion. And they've said that if they don't get the 1.2 billion, they initially said if they didn't get it by August 1st, they would be furloughing 13,000 of their employees, which is about 70% of their workforce, right, until some point in the future. Members of Congress looked at their numbers and they said, okay, this 1.2 billion is actually through the end of the year, not through the end of the fiscal year, which ends September 30th. So you have a little more money than you claim. So they extended that date from August 1st to August 31st. But now we're already at August 9th. August 31st is coming up. So bottom line here is they're requesting Congress to give them an additional $1.2 billion in funding. Okay, now members of Congress are saying, sure, well, we'd like to give you the money, but we need you to fix the way you're doing things, because obviously if you're running a budget shortfall and applications are already so expensive, there's inefficiency here that needs to be fixed. So that's the debate that's happening right now. My guess is that the funding will probably go through. I would probably put that about 75% chance, because if the funding doesn't go through, it's going to be really bad. The immigration agency already has been taking a long time on applications. If they're working at 30% capacity, and it's, different agencies within USCIS would be affected differently. The asylums are worse, naturalizations are worse than say the H1, but even so, we would expect processing time to get much more slow than it already has been if the furloughs happen. So if the funding is not passed by August 31st, for a few months at least, we're going to see very significantly delayed processing. And by the way, this has nothing to do with COVID. This is just something that's happened as the result of the last few years of adjudications. Okay, so that's something we're all watching out for. Now, the other thing that's happened in the last couple of weeks does relate to COVID. So for a long time now, the F1 regulations have said if you're an F1 student, you can take at most one class online. Okay, the rest of your classes have to be in person. Now, when COVID hit in March, immigration relaxed that. They said, all right, if you're already a student, we know the regulation says you can take max one class online. We're going to allow you to take all your classes online, right? A reasonable approach. Then later, sometime this summer, they said, if you're a current student, that rule continues to apply. You can still take all your classes online. But if you're a new student, you have to be taking at least some classes online. Otherwise, we're not going to let you in. Now, this was challenged again by multiple parties, including Harvard and MIT. And basically there was a settlement. And as part of the settlement, the immigration has backed off from that requirement, right? They've backed off from that guidance that says that in-person studies required for all students. So the bottom line is that the old rule from March continues to apply, right? And previously that rule only applied to continuing students, but now newly admitted students are also going to be subject to that original rule. So basically new students need to have at least one class online. That's always been the rule. Continuing students can continue to be taking classes completely offline. So there's kind of a distinction there. And this is the result of that settlement. So it's not, the settlement is good. It doesn't say that all students can take all their class online. Rather, it says that anyone that's already been here can continue to take classes online fully. But new students need to take at least one class online. And universities are responding to that in different ways. They're coming up with kind of new strategies to have that one class, maybe in an auditorium or outside, so that the risk of COVID can be kind of alleviated while still complying with that rule. All right. The other thing is on June 22nd, this is kind of big. The Trump administration came out with an executive order banning visa stamping for H, L, and most J visa categories for the rest of the year, with a number of exceptions. And there's a ton of exceptions to this. There's a lot of nuance involved as well. So what does that mean? And it's actually piggybacking on another immigration ban that relied to green card stamping. Okay, and I'll take you through what both of those are. So basically, the green card stamping restriction Doesn't apply to anyone that's applying for a green card here, meaning adjustment of status or I-140, I-130, none of those are affected. This is only relating to consular processing of green cards. So if you're going through the NVC this is someone that's not in the country. They're applying for a green card through the consulates. This restriction applies to them, okay? And what it says is if you're outside the US on April 23rd, right? You didn't already have a green card stamp on that date, and you didn't have an advance parole, you're barred from coming in to the US through the end of the year, through December 31st. So you're not going to get your green card stamped through the end of the year, right? Now there's exceptions to that. The EB5 category is accepted. Spouses and children of US citizens are accepted, so that's the immediate relative category. Healthcare workers and some other essential workers that basically work in positions that the government thinks is important. All of those people also can continue to get their green card stamped at the consulate through the end of the year. Okay, so people are calling it a green card ban. It's not a green card ban per se, because again, if you're applying for adjustment of status, you're applying for I-130, I-140, EAD, none of those things are affected. This is just for people that are applying for the green card through consular processing, typically for relatives that are in India or some other country. Those people could have to wait until January 1st to finish their process. Again, unless they're falling in one of the exceptions. Exceptions being EB5, the immediate relative category, if they're healthcare workers or if they're essential workers for the government. So that's the green card restriction. So the June 22nd announcement, what it did is extend that green card restriction all the way through the end of the year, okay? That's the first part. There's a second part to the June 22nd executive order, and that applied to the H, L, and J, okay? It doesn't apply to students, doesn't apply to F, doesn't apply to B. What that says is that if you're outside the US on June 24th, okay, and you're outside the US and you didn't have an H, L, or a J visa stamp already, meaning you needed to apply for one, and you didn't have an advance parole, then the consulate is not going to stamp you through the end of the year for H, L, or J. All right. Again, there's a whole number of exceptions for that. Now, some of the main exceptions are from the rule itself. So remember I said, if you're outside, this only applies if you're outside the US on that date. So presumably if you're in the US on June 24th, this restriction should not apply to you. That's what the plain words of the executive order mean. And that's pretty much the consensus among immigration lawyers that have read the executive order. But what's interesting here is that the administration didn't mean that, because the Department of State came out with a tweet a couple weeks afterwards that seemed to say that even if you are here in the US, they're not going to allow you to go for restamping. But again, that is contradictory to the executive order language itself. And that inconsistency has not been resolved. They've resolved some of the other inconsistencies, but not that one. So to this date, if you're here in the US on H, L, or J, if you already have a valid visa, you can travel, that's fine. Right? There's no issue about that. But if you're here in the US and you're here in the US on June 24th and say you need to go for stamping, and let's assume that travel is allowed. There's all these COVID restrictions as well, but let's assume that travel is allowed. It's still unclear whether you can go for stamping or not based on the fact that you were here in the US on June 24th. The executive order says that you can go for stamping. A DOS tweet later said that you can't go for stamping unless you fall under one of the exceptions. So we'll have to see how that transpires. Now, again, there's assuming that you're outside the US on that date, you're subject to the bar on HL or J stamping. There's still a number of exceptions that apply. And again, the June 22nd visa ban for HL and J doesn't apply to students. Okay, so it just doesn't apply to students at all, one way or the other. So again, now as I said, there's a few exceptions to that rule as well, right? So again, if you're working in the national interest, generally if you're working for a government agency, and not just any government agency, it has to be something that the consular officer feels is in the national interest. You could still get a stamp. If you're working for, it's kind of interesting, national interest would probably include healthcare workers as well. And also if you're working in a position that's essential to the US food supply chain. Okay, that's kind of a curious exception, but I guess what they're saying is that, they don't want anyone that's working in a position that helps feed the country to be barred from coming in. So the HLJ ban has one exception for people that are working in the food industry. There's a number of other exceptions. So if you're a spouse of a US citizen or a child of a US citizen and you don't have any other status, you can only come on HL or J. You can still come in this year. You don't have to wait until January 1st. And then more recently, it's a very important exception that was announced. The government said that if you're a dependent, so if you're an H4, an L2, a J dependent, and you're stuck in India or some other country and your principal is here, you don't have to wait. Okay, so they're not going to separate families through until January 1st. There's now an exception for those people. The language of the executive order didn't mention exactly that exception, but I think the administration realized that was pretty unfair. So they're allowing that exception as well, I guess, as essential people. All right. So again, if you're applying for an HL or J, and it's most Js, there's some J categories that are not applying, that this is inapplicable to, generally the research Js, but most Js, HL, H, and L, you're not going to get stamping through the end of this year unless you're falling under one of the exceptions I mentioned. All right. The June 22nd executive order also had some language directing DOL, USCIS to look more carefully at their adjudications to protect US workers more. Okay, now this is something that many executive orders at this point, at least 3 or 4 from Trump, have said. He keeps on saying, protect US workers, protect US workers. A couple years ago, the Buy American, High American executive order came out. Some of you may remember that one. As a result of that, we saw a lot of RFEs coming from USCIS, specifically on level 1 wages and specialty occupation RFEs. So that's the source of those RFEs. It came from that executive order. So this year's executive order from June 22nd has similar language. It's saying, protect US workers. So we'll have to see how the immigration authorities respond. And generally, it would be more RFEs. What's interesting here is that now they have this furlough that's coming up. So there may not be the capacity to increase the RFEs, even if they want to, or they may increase the RFEs and processing time may just take months and months and months. That's unclear. That's assuming the furlough even happens, right? So that's something that will be seen in the near future. One thing we've already seen is DOL and USCIS issued kind of an agreement where they're going to share data on companies that violate immigration law. So for some reason, they were not already doing that, but now they will be doing that. So for instance, if you have a site visit from USCIS on the H1 side, and the site visitor finds there's some underpayment of wages, the site visitor now can share that data with Department of Labor, and you can expect a Department of Labor audit. So again, this is on the H1 side, right? So that's one consequence we've seen from the June 22nd executive order, where Trump said, protect US workers more, okay? And as I said, we may see more RFEs as well. So that was the big one, the June 22nd executive order. The other thing that relates to H1 also is, at the beginning of this call, I said, remember that USCIS has been losing in federal court a lot because they've taken a very unreasonable position in many of their cases. One area where they had a big loss was the IT-Serve settlement. So IT-Serve is an IT association, many of you will know. They are basically an association that represents the interest of IT consulting companies, mostly Indian companies. And they got together, and some of these decisions by USCIS, especially on the H1 side, have been pretty unreasonable. Approving cases retroactively, so you're now out of status. Approving cases for 1 or 2 days. Short dating approvals that way. Denying cases even when you have very clear proof that there's work available, client letters and all that. And to the reasonable third party, these were not reasonable decisions, right? And the judges in a number of these cases actually agreed. And USCIS suffered a number of losses at the hands of IT-Serve. And what they did is they basically entered into a settlement. USCIS entered into a settlement with IT-Serve, which is something that in my 15 years, I've never seen anything like that. It's very unusual. Where they said, where they backed off from a lot of these policies. All right. So one of the things they said is they're not going to enforce the itinerary requirement. Itinerary requirement is basically, it's a requirement in the regulations that says, if you're here on an H1, we need to know what you're going to be doing for the time that you're requesting, right? So if you're working for 3 years, we need to know where you're going to be for those 3 years. Generally, people said, well, this person will be my employee for the next 3 years. That meets the itinerary requirement. But USCIS more recently has been saying, no, but you're a job shop. We don't know where the employee is going to be. I need to know every single day where this person is going to be for the next 3 years. Now, again, that's unreasonable. Very few companies, even non-IT companies, know exactly where their employees are going to be for sure for the next 3 years. I mean, I'm an immigration lawyer. I generally know where I'm going to be in my office, but I may move. Things happen. So there was an unreasonable approach, and the judge struck it down. Okay, in a number of cases, not across the board in those cases, but that resulted in USCIS coming to a settlement with IT-Serve. And the settlement says until USCIS comes out with new regulations on H-1B, which they're planning to do, they will not be enforcing the itinerary requirement, and they will also be basically demanding less documentation in cases where the H-1 worker is working at a third-party site. Right, so a lot of IT consulting obviously involves working at a third-party site, the end client site. We've been seeing very long RFEs the last several years now, where they want client letters and vendor letters and all types of documentation showing what the person is going to be doing at the end client site. What basically the IT-Serve settlement says is the level of documentation that USCIS is going to demand is less. Okay, now this is not permanent, but for the near future, that's what's going to happen. I think what USCIS's strategy is, and this is something that not many people know about. The reason why IT-Serve won a lot of these cases is because the judges said, USCIS, you've been applying these higher standards not based on any regulation, but based on memos, right? So there was a third-party worksite memo from 2018, and there was a famous Neufeld memo from 2010. And the judges said, under the law, under Administrative Procedure Act, you can't make these significant substantive changes just based on a memo. You have to go through the rulemaking process and make it a formal regulation. Right, now that takes time, it takes resources. It's much easier for USCIS just to put out a memo saying, oh, this is how I'm going to be applying immigration law now, which is why they do it that way. But the judges said, no, you can't do that. You have to follow the proper procedures. So in the meantime, we have this IT-Serve settlement, but in the near future, USCIS will be coming out with a new regulation on H-1B. And I expect once that regulation comes out, we may see some of the same standards reapplied. So the employer-employee standard, I expect that to probably come back. I'm sure the regulation will specifically say, if you're working at a third-party site, we need ABC evidence. So that remains to be seen. Now, what's interesting here is that we have an election coming up, obviously, right? And Biden is expected to win at this point. from the immigration advocate side, that would be the best case scenario by far, because another 4 years of the Trump administration is going to be very bad for pretty much all immigrants. We're going to see much more restrictions on H, definitely more restrictions on F. They already have OPT and CPT in their target, and other immigration as well. Obviously, asylum, naturalization, all of these things. So it's very big that Biden wins. If he does win, which is predicted based on the polls, a lot of these policies that are planned, such as the repeal of H-4 EAD, the new H-1 regulation I'm talking about, they may not come out, right? Because what happens is a new president comes in, they have political appointees, and the political appointees set the tone at USCIS, right? So Ken Cuccinelli and Chad Wolf, these are political appointees right now. They're very anti-immigrant. They're forcing the agency into these anti-immigrant policies. But if Biden wins, there'll be new appointees, and those appointees will hopefully relax some of these requirements. That's to be hoped, and let's see what happens there. Right, so that's my summary basically on what's been happening in the last couple of months. I can now switch over to some of the questions.
Wow, it's a lot of information. So now let's get to the questions. Hopefully we can answer those, some who registered already and some will come up. Some of them are coming on the Zoom chat, but we'll go one by one. And let's see, each question will be asked by our team members. So I'll start with the questionnaire. Bindu, you can start, then the rest of the questions will follow by the team members. Unmute yourself.
Yep, got it. Thank you, Mr. Tiwari. This is such an ever-changing, fluid situation. So thank you for coming and educating us. So we have a first question on H-4 and H-4 EAD applications. The question is, how can we expedite H-4 and H-4 EAD applications? Are there any special extensions due to COVID and furloughs?
Yeah, that's a good question. The standards for expedite have not changed under COVID. It's still the same. The procedure is you basically call USCIS customer service and explain what the reason for the expedite request is. The expedites are given very sparingly. Generally, a business reason is not good enough because, especially H-4 EAD or H-1 is by definition an economic visa, right? So loss of a job usually I've seen does not result in an expedite. It doesn't hurt to try it, obviously, especially if, the loss of job would be very catastrophic. But at the same time, you also don't want to kind of hint to USCIS that, oh, I may become a public charge if I don't get this this visa, right? So it's kind of a catch-22 there. But generally, for any humanitarian reason, so if you have anything related to health, generally is a very strong basis for expedite. So one example might be, okay, I have a child that is undergoing very expensive treatment. If I lose my job, I'm going to lose my insurance. So for that reason, I need to have my H-4 EAD expedited. That might be a good reason to get the expedite done. But if it's just, I'm going to have to move out of my house, I can't pay my mortgage, which is obviously very significant. Generally, that doesn't work as an expedite because many people, that's the basis of the visa.
Thank you. Next question.
Thank you.
Isha, go ahead.
Yeah, thanks, Mr. Akshay Tiwari, for being with us with a wonderful session. Is there any risks involved at this time from converting from H-4 to F-1?
Well, anytime you're filing an application, obviously there's some risk of denial. When you're switching, well, one thing I would say is if you're on H-4, you can already take classes, right? You don't need to be on F-1 to take university classes while on H-4. So maybe you don't need to do the application at all. What the person may be hoping to do is get on F-1 for F-1 CPT, or maybe finish the program and get OPT after that. If that's the intention, then F-1 does make sense. F-1 has a non-immigrant intent requirement. So if you have an I-140 that's been filed in your favor, or even if your name has been included on your husband or wife's I-140, USCIS might use that as a basis to deny your F1. And generally, you need to show when you're filing for a change from H4 to F1 that you have a foreign residence, that you intend to leave the US when your F1 is done, that you have ties to your home country, that you have assets in your home country, you have family ties to your home country. The standard for meeting that is a little bit higher on F1 than for H4. Right? H4 doesn't have a non-immigrant intent requirement. So there's a little bit more risk involved in that kind of application. Now, it doesn't mean you don't try, because if you're on H4 and you've been maintaining status, so if you're on H4 and your spouse is on H1, your spouse is maintaining H1 status, getting paid, no irregularity there. If you file on H4 to F1, and for whatever reason USCIS feels that your ties to your home country are not significant, suppose, they'll just deny that application, but they, in vast majority of cases, will not take any action on your H4 status. So you'll just continue being on H4 status. So it may make sense just to apply, but switching to F1 is a little bit harder than switching to, say, H4. You do need to make sure you present a very good case, you have all the proper documentation, and you're meeting the regulatory requirements. Okay.
Yeah, thank you very much for the detailed answer. Thank you.
Sure.
Thank you. Next question, please. Jyoti, go ahead.
Hi, Mr. Tiwari. Good to have you here. This is Jyoti Gandhi. I have a question on F1B. I have a question on H1B. Is having a stamp compulsory if we never leave the country and just stay here until the next H1B renewal?
No, so stamp is only required for entry into the US. So in that example you gave, if you're here, you keep on extending your I-94, you're fine. You don't need a visa stamp.
Okay, so just for the extension of it, like when can we expect to leave the country if it is safe for us to come back with a stamp?
So again, if you have no intention of leaving, you don't need to get a stamp. You can just keep on extending your I-94. But if you do need to get a stamp, you have to worry about the visa ban that I discussed, right? The June 22nd restriction on H, L, and J visa stamping. So as I said before, there's a difference in opinion right now. It's unclear. There has not been any clear guidance from USCIS or DOS about whether someone that was here on the US with or without a visa on June 24th can go for stamping sometime this year in 2020, right? A Department of State tweet said that they cannot unless they fall under one of the exceptions. But the language of the executive order and one of the other exemptions that they came out with for the H4 spouses, that's also had language that kind of suggested that someone that is here in the US on June 24th can go for stamping for the rest of the year. So until that's resolved, effectively, it's not worth taking the risk. So I would say if you can avoid going for stamping, if you're on H or L through the end of the year, avoid it. If you can avoid it, then obviously you have to do what you have to do. You would try to come back in using that exception that you're here on June 24th, or one of the other exceptions that basically you're an essential worker, the job that you're doing helps the economy. But I will say that thus far, Department of State has not been stamping very many essential worker exceptions that I've heard about. Rather, I've heard that they're denying many. So again, until there's some more clarity on that exception that I mentioned, it's probably best to avoid stamping.
Okay, that explains. Thank you.
Garu, next question, go ahead.
Yes. Hi, Akshat. The next topic is, this is the trick we used to use in, back in the day, right? So cross the border and go to Canada. So the question is, given all these things happening, mostly due to COVID and all the laying off and, furloughs for business reasons, right? So any H1 holder currently, his or her loses a job And if they find a job in Canada, assuming that they can enter Canada through a visitor visa or whatever, work visa, work there for 1 or 2 years, and are they allowed to come back to the US before the 6-year H1 expires? Is a cross-border transaction allowed? I guess is the macro level question at this point. Thank you.
Sure. In that scenario, someone on H1 is given 6 years of time on H1B, right? So say you've spent 3 years already here in the US, you lose your job, you go to Canada for 2 years, or even 4 years, or even say 10 years. You can still come back and recapture that remaining 3 years that you have out of your 6 years at any time. That's the first thing. Second thing is, if you have a green card process that's underway, suppose you have an I-140 that's approved, even if you have used up your 6 years, suppose you use up your 6 years, you go to Canada, it's 5 years passes, but you have an I-140 that's approved, and the priority date for that I-140 is not current, you can come back in for another 3 years on H-1B at that point, and this would be exempt from the cap. So there's a lot of options in that kind of scenario.
Excellent. Thank you, Akshat.
Next question, please.
Hi. Hi, Akshat. Thanks for joining us. I have a question. Given the current COVID situation, what is the projection for H1 visa submissions in 2021?
Well, submission. So does that mean visa stamping or filing?
For filing H1s. So that many people couldn't submit for 2021, and then there could be overwhelming visa submissions. What are the procedures? I heard fee also reduced for 2021. How is it going to be handled?
Yeah, well, the fees are actually increasing from October. For some applications, as much as 80%. Some applications are actually going down, but generally fees are increasing. So the fees part would probably be higher. The H1 lottery is not changing for next year, even despite COVID. So that's going to be the same. Again, unless there's some regulation that comes out that changes it, but there's no discussion about changing the lottery for COVID. So I don't think that's going to change. The only thing really relating to COVID on the H1 side is this June 22nd visa ban, right? Because the rationale of the June 22nd visa ban was COVID. They're saying, okay, COVID is rampant. We don't want people coming here infecting. So that's why generally HL and J visas will not be stamped through the end of this year. Now, suppose Trump wins, right? If he wins, then he's in office in January. And suppose COVID continues to be a problem, which I expect it will be, then it's very possible that Trump could extend this existing visa ban that's going to end on January 1st for another few months, right? That's very, very conceivable. If Biden wins, he's already said that he's going to not extend that visa ban, right? So even if COVID is pretty bad, there may be some different restriction that he'll put in, but it's not going to be this same visa ban, because I think many people know that even though the rationale is mentioned as COVID, the reason why he's really doing it is because it's an maybe anti-Indian, but definitely anti-H1 kind of animosity that he has. And the reason we know that is because, many other visa categories are not accepted, right? So O's and P's and F and all these other people can still come in. Why is it just that HL and J's have this restriction? I mean, if it's really COVID, then no one should be coming in theory, right? So, yeah, I think bottom line, if Trump wins, we probably see an extension of it into next year. Right now, it ends January 1st. And if Biden wins, I don't think we'll see an extension.
Got it. Thank you. I think it's really depends on the political situation.
Absolutely, yeah.
Next question, please.
Thank you, Akshay, for joining us. My question is around Build America visas. How does it work and what impact it has around employment-based or family-based categories?
Sure. So Build America is Trump's idea for basically a point-based system. I don't think there's any chance of that passing the way that he's devised it. The reason for that is even, A, he may lose, but B, even if he wins, the House of Representatives is Democrat. And it's going to be Democrat for at least the next 2 years, and projections are for another 4 years or so. And the reason why that matters is because Trump cannot unilaterally change immigration law. Immigration law has to go through Congress. And any law in Congress has to be passed by both House and Senate. So even though Senate is Republican right now, they may change after the election. Any kind of immigration plan that Trump comes up with or his allies come up with is not going to pass the House, right? And Build America, what that does is instead of having family-based sponsorship and employment-based sponsorship, it'll just be a point system. If you have a PhD, you get 2 points. If you have master's, you get 1 point, that kind of thing. And then those numbers are not exact, it's just an example. And many people are in favor of family-based immigration and some of these other policies. So the way he's come up with it, it's just not going to happen. I wouldn't bother even reading about it because the House would never pass it. Now, what very well could happen, especially if Biden wins, is that there could be comprehensive immigration reform. Obviously, there's many parts of the immigration system that are broken, that need fixing. And if we have a Democrat president, and the Senate goes Democrat, which is about 50-50 projection right now, then you have all three, President, House, and Senate, that are Democrat. I would put the chances of some kind of immigration reform bill, comprehensive, at around 90%, right? Because that's something that they definitely want. Republicans are very anti-immigrant generally, and they're also very anti-comprehensive immigration reform. They're more interested in like border wall and ICE funding and CBP funding, that kind of thing. More enforcement, not really benefits. So yeah, again, a point system may get implemented as part of a much broader comprehensive immigration reform bill, which itself would only happen if the Democrats win both House and, Senate and presidency. They already have the House. And if it does happen, then the point system is going to be part of many changes. So it may be a point system plus family-based, any number of things, but it's not going to be the way Build America is.
Okay, thank you.
Next question, please.
Who do you think?
One second, Ajay. Let's go ahead, Yashoda.
Thank you for joining us, Akshat, and a very informative session. And my question is, will the continued payroll protection program help immigrants? If so, how? You are on mute.
Were you referring to the PPP payroll protection program?
That's right. That's right.
Yeah, that program is sort of agnostic to immigration status. It doesn't really matter what your immigration status is one way or the other. It's really just for businesses that were impacted by COVID, which is pretty much everybody. And, they get a certain, basically 2.5 months worth of their payroll costs they can get as a loan. And if they maintain certain employment levels, they can have that loan forgiven by the SBA, Small Business Administration. And that applies, irrespective of whether the company has many H-1s or J-1s or anything like that. It's not tied to immigration status.
Okay, thank you.
Hi, Akshat. Yeah, this is Srinivas. In the case where F1 and H1 visas got stamped but they can't come to US due to COVID. What happens to their visa status?
Right. So suppose someone has a stamp already and they can't come in. Well, it sort of depends on the basis for their status, right? So suppose someone is on an F1 program at a university. Say the university starts in September 1st and it's already October 15th and you haven't come to the university yet. At that point, the university may say, well, you're not attending classes, so we're going to cancel your I-20. We're going to kick you out of the university. So at that point, the student may have to get a new I-20. If the visa is already stamped, it's a new I-20 say for January 1st admission. The visa is already stamped through January 1st, then the person could just get the new I-20, come in, January 1st using that existing visa and come in that way. Now, if the delay is such that you can still come in without losing your university status, then fine, you come in later on. But generally, if there's a delay, you're not attending classes, you probably have to at least defer, if not apply to a whole new program, and start at the next start date. Now on the H1 side, it's more relaxed. As long as your job is available, you have an H1 approval notice that still has time left, and your visa is valid, at any time you can come back. So there's more flexibility there.
Okay, thank you.
Next question, please. Ravi, go ahead.
Yes. Actually, this is a two-part question. So one is, what is the impact on the H-1B and L-1 Visa Fraud and Prevention Act? Hopefully I didn't mess it up, but that's the question from the participant.
I'm not sure exactly what that act is. It's a very vaguely worded act. So I'm not sure what that is. Maybe, I can look it up. Many of these senators and congressmen come up with acts that have that kind of name. There's been probably dozens of different bills that all try to deal with that. So the specifics of that one, I'm not sure. What's it called again?
It's called the H-1B and L-1 Visa Fraud and Prevention Act. That seems to be a very generic term, though.
Yeah, no, I can quickly look at it. Yeah, there's one from 2007 with that name. There's another one from 2017. H1 and L1 Visa Reform Act of 2017. So yeah, I'm not sure which one it is.
No worries. Absolutely fine. All right. The second part is, again, this is a political question based on a senator's view, but what is Senator Dick Durbin's stance on H-1B immigration?
Well, Durbin has been very famously anti-H-1B. Durbin and Grassley from Iowa have, over the years, put a lot of pressure on the immigration authorities to clamp down on what they see is fraud in the H-1 industry. Right? This push for client letters ever since 2010 actually is based on a lot of badgering from Durbin and Grassley in the mid-2000s, where they said, okay, you have all these IT companies, they're shams, they're job shops, they're taking jobs away from US workers. Immigration, USCIS, what are you doing to put a stop to that? And then USCIS responded by having all of these additional requirements. So his position has been generally quite anti-immigrant. Well, anti-H-1B. I'm not sure if he's anti-immigrant per se, but he definitely doesn't like the H-1 program.
Sure. The second question again from one of the members is that broadly in the F1 program, did any changes happen from, let's say, 1993, since the first attacks, the World Trade Center and the official 9/11? Did you see any major changes in the F1 program since then?
Well, the program has changed very significantly. You mean just between those two time periods or since?
It is after any change is after 1993, the initial attack, and then after the actual 9/11.
Okay. Yeah, well, I mean, the program has changed very significantly since then. One area is the expansion of OPT. So OPT back then used to be just the 1 year post-completion OPT. Since then, we now have the STEM OPT, right, to encourage people graduating from those science, technology, engineering, math programs. So in a sense, that's been, a favorable expansion. I think the number of people on OPT has ballooned big time since then. It was a lot smaller before. So in a sense, it's been more permissive.
Thank you. Back to Sridhar Garu.
Anu, you want to go ahead for the next one? Anupara.
Sorry, I was talking on mute. All right, the next question is related to the green card renewal. So if someone's green card is getting expired before December 2020, and while they're applying online, can they go to a local office to get their green card stamping done for the renewal?
Yes, so if you have a green, this is now a new renewal of just the card, right? So someone that's on a green card, once you're a green card holder, you're a green card holder for life, right? Unless someone takes that away. Now, in order to travel, you want proof of that, right? And that's what the physical green card is. So when someone is, and the cards are usually valid for 10 years. So say your card is expiring, you've applied for a renewal of that. Sometimes that takes a long time for processing. And that's what this question is asking. So say you've applied for that extension of the green card itself, you need to travel. Can you get what's called an ADIT stamp in your passport, which is basically temporary proof that you have a green card, and you can use that to travel. And that's been that's still the case. That's been the case for some time now, where basically you set up an InfoPass appointment. Before, you used to be able to set up an InfoPass appointment directly online. Now you have to go through USCIS customer service, and they'll set the InfoPass appointment for you. But basically, you call customer service. You say, I have an I-90 that's been filed. I have the receipt. I need to travel. Please set up an InfoPass appointment for me so I can get a temporary I-551 stamp in my passport, and that's possible. Now again, with COVID, many of the offices are just now reopening, and they're, the appointments are kind of trickling in. They're doing a triage situation for the priority of the kind of cases that they're seeing. So there may obviously be some delay. There's also variability between different offices. So offices in areas that are not as badly hit, like New York, for instance, are probably much farther along than, say, Florida or Georgia, Texas. So there's going to be some variability there, but generally that procedure still is there.
Thank you.
Thank you, Akshat. I'm hoping you have time for a couple more questions.
Sure.
Okay. So on that same note, same person is asking, if anyone is receiving stimulus, is it important on its impact on H-1B or a green card process?
No. The public charge, as it is the public charge component, based on that rule from 2018, is stayed by a court right now. And even when it was in effect, acceptance of the stimulus was not a negative factor for public charge, so that's fine.
Okay. Thank you. The next question would be, I know there are so much going back and forth, like especially for these F1 visa holders, they don't know whether they need to stay here to finish their master's education or they need to go back due to that online processing, online classes and everything. Then it was going back and forth. Now, just a gist of it, what did this prestigious university claim in their last recognized USCS? So it got changed suddenly, and now I hear it, they don't have to leave the country. Maybe you can just briefly, outline that some of that information, so that it would be very helpful.
Sure. Yeah. So the bottom line there is, there was a change in policy. Harvard, MIT filed a lawsuit. They won that lawsuit. Basically, there was a settlement. The bottom line here is, if you are already in the U.S. on F1 status, the SEVIS program has already allowed you to continue to take online classes, right? All your classes online, 100%. They made that change back in March when the COVID first hit. So you can continue to take all your classes online. If you benefited from that change back in March, that continues to give you the benefit of taking all your classes online. Now, if you are not already here in the US on that date on an F1 stamp, right, which means you're a new F1, you're just coming in for studies, for you the rule is different. For you the rule is what it was, in say a year ago, which was that maximum one of your classes can be online, right? So that's the rule for you.
Thank you. And the next question is just a general, do you foresee priority date move for green card process? I know as is, USCIS is very late in doing it. On top of it now, I know you did explain about the funding of it might impact it. Now on top of it now, COVID-19, so much is going on, but I know a lot of people waiting to apply for this green card, but do you see anything movement in that process?
Yeah, so it's kind of interesting because of COVID, the number of applications, especially the consulates, obviously dropped down. So there were a lot of unused visa numbers. And because of that, you've seen EB3 jump by many months, like about half a year. So this month, it's in 2010, whereas last year was sometime in 2009. So ironically, COVID has actually made the EB3 India category jump up pretty significantly because there was a lot of unused visa numbers. And many of the other categories have also benefited. EB2 India has not really changed significantly because there was already demand in that category, but EB3 India has jumped. Now, October 1st, there's a new allocation of visas, right? So if COVID is continuing to be a problem at the consulates, which I expect to be the case, we may see better movement on priority dates next year, meaning from October 2020, next fiscal year as well. Because again, there won't be that many people applying at the consulates, which means that there's more visas available at the USCIS stage. So generally priority dates will jump up. And the dates for EB2, EB3 may improve faster than they would have otherwise.
Thank you. There is another question just on the chat. I'm sure you might have, but if you can reiterate, I think students who came here on student visa go back to India due to COVID, obviously, and not only that, not only COVID, and also some universities initially said it's only online classes. You have to go back to your country, or you can take from classes from anywhere, kind of. But let's say COVID, once the schools open, can they come back on earlier visa? Because now some universities say, yes, you can stay here, take some classes online, some on physically. So their visa is, I think it's valid still, and they can come back on that same visa status?
Yeah, so there's two issues there. One is if you have a visa stamp that's valid, right? So anyone that's coming in needs to have a valid visa stamp. So if they already have a valid visa stamp, that requirement is met. Now you also need to have an I-20 when you're coming in. It could be a new I-20 or it could be a continuing I-20. Continuing I-20 is for someone that's already at a university. maybe they got deferment, maybe they just went on vacation, whatever the case may be. If you're coming in on a continuing I-20, the rule that you can have all your classes online applies to you, right? Because you benefited from that rule change back in March. You're still in that program, so you can come in and take all your classes online. Now, suppose you need a new I-20, so let's call it an initial I-20. If it's an initial I-20, then then basically you need to have at least some of your classes in person. So that's the distinction. You need to have at least some of your classes online, and as always, you need a visa stamp to come in.
Thank you. And one more question. I hope we are still okay with time options.
Yes.
Okay, thank you. I just want to make sure you are okay before we bombard with the questions. Anu Para, do you have a question? Go ahead.
Yes, on the same note, Akshat, regarding the student visas, if Trump's administration, they don't rescind the virtual learning executive order, what are the possible consequences that the student graduates possibly could face?
So if Trump does not rescind the executive order, what are the consequences for students?
Right.
I mean, the executive order doesn't affect F1s. Maybe the question is kind of asking someone that's on an F1 and has a cap case that's been approved to H1. So someone in that scenario generally would have to wait until January 1st. Unless that exception I mentioned before about being physically present in the US, whether that takes effect or not. So again, the conservative approach there is, even if you are here in the US, say on F1 status on June 24th, you would still not be able to get an H1 stamp until January 1st. Now, remember, there's exceptions to that. So if your job is in the food service industry, or if you can claim that you're an essential worker, you might be able to apply for an exception. But those exceptions are a little bit difficult to get at this point. You know, practically the difference between coming in October 1st versus January 1st is just a matter of 2-3 months anyway. A lot of jobs are work from home, and there's restrictions for travel. So it practically may not be, that much of an issue, especially for cap cases who are already, they already have to wait until October 1st, right? So it doesn't affect them that much.
Right, and just a follow-up question on that one. There are many American consulates also closed in India. Any idea when they are going to open? Is this based on the local lockdown situation, or is there any exemption to that?
Yeah, the consulates also are slowly opening, but it's impossible to predict or even define how much they are opening. The essential services are open, citizenship services are open, but stamping is being open on a piecemeal basis. We can't say exactly when your case would be approved. I mean, generally they are opening, but at different stages. That may change depending on how COVID transpires in the fall, right? We all know that there's an expectation that COVID is going to spike in the fall. So if that happens, then the consulates may shut down completely again. So there's just a whole lot of variability. It's not possible to answer that question.
Okay, thank you.
All right, Akshay. So two-part question, again from me, Ravi, is that the question is, if unused green cards in that category be given by USCIS to employment-based applications?
Yeah, so unused green cards, so for instance, there's a lot of EB-5 unused green cards apparently. So some of those numbers are pushing up to some of the other categories, which is why, for instance, for EB-1, we've seen some progress across categories, including in India. EB-3 India, as I mentioned, is benefiting from unused visa numbers across the employment categories. So the visa bulletin, the sort of the czar for this visa bulletin, his name is Charlie Oppenheimer. He kind of dictates what the visa numbers are, and he does predictions based on demand to try to make sure that all the numbers are used. And what he said is that because of COVID, there's a lot of unused numbers in different categories, and he's shifting the numbers around to the categories where they will be used. So that's the reason why we're seeing EB3 India jump by 7-8 months, but no real movement in EB2, like maybe a month or so, because it's all based on the demand. But there's definitely shifting based on unused demand that's happening.
Okay, thank you. The second question is that if somebody's physical green card is expired for whatever reason, based on the time, and then they apply for a renewal, you have to send it to CIS and do all the process. And if they want to apply for a job in the meantime, filling out the I-9 form and all that, right? Can they submit the expired green card in the meantime?
Yeah, that's a good question. Let's see. I'm going to look at the I-9 requirements because it's kind of a chicken and the egg thing, because if you're a green card holder, you're a green card holder for life. But at the same time, in order to apply for a job, you need a valid evidence of your current work authorization. So if you look at the requirements, 1 second. Yeah, I would say you need a valid green card.
Okay, so basically he or she has to wait for the new card to come in and then use that for the ID purpose for the application. I guess. Right. Yeah. Okay, Akshay, thank you.
Are we okay on time, Akshay?
Yes.
Okay. Bindu, I see a question from you. Do you have a question? Would you like to pose that? You're on mute.
Thank you. Yeah, one of the questions is, how does the recent changes affect the hiring process among the employers? Do you see the process being complex and taking too long?
Well, so premium processing has now come back into effect, which I think has probably made the hiring process easier, at least for now, because especially say in an H-1 transfer situation, a lot of employees will say, look, I'm not going to join your company until my H-1 is approved with your company, right? Because I want to maintain my status. I don't want to be in a position where I've joined your company and the case is denied. Now I'm out of status, right? So a lot of employees in new hire situations will insist on approval. And now that premium is back, I think that makes it easier to have them onboarded sooner. Now, of course, if the furlough happens, that may kill premium processing. Premium processing is kind of a cash cow for USCIS, so they may continue it actually even with the furlough. It's quite possible, but if you're working at 30% capacity, I would expect premium would probably go as well. So again, if the furlough happens, I think it'll definitely make hiring a lot more difficult. But if they do get the funding and premium remains in effect, then I think for now it's a lot easier to hire, at least from immigration side, than it has been in the past. Right, we're seeing fewer RFEs because of the IT serve settlement. Premium makes the case go faster. So administration-wise, I don't think it's any more difficult than it has been. It's probably a little easier. Now, practically for COVID and all that, a lot of companies may not be hiring. So for instance, say you're working at, if you're an IT company, maybe some of the placements are drying up. So it may be harder to find projects for people. But that's, that's a different story. That's not on the immigration side.
Thank you.
Thank you, Akshat. I think I know it is a very interactive and educational session. I know when we asked you, we never expected we might go this far on the call on the session, but looks like it is a very needed topic for everyone. Just as a closing, a remark, basically one more question I want to pose it. I know there are so many changes, and not every one of us very familiar with all these changes and visas and all those things. I just want to ask you, your opinion, as an individual or an organization, how can we help the community whenever we hear all these changes? So what would you suggest us so that as a community organization like Telugu Finance Society, what can we do as a TFAS level or an individual level? So please share your thoughts.
Yeah, that's a great question. Immigration is a political process, right? And as members of the public, we have the ability to influence the political process in different ways. And organizations of people are more powerful than an individual, right? So if I'm just an individual, I can call my congressman or senator. Maybe they'll listen to me, maybe they won't. But if it's a collective of people, then you have more power, right? So you can leverage that collective capacity that you have to try to make some changes. Now, how would you actually do that? Well, you can do that in many ways. So one is you can have petitions. So you can basically do an online petition, have all of your members and their family members sign that petition and send it. There's White House has petitions that they accept. There's petitions that can be sent to different members of Congress, right? Your particular member of Congress, as well as all of them. Again, your senator, both your senators, or all of them. So there's various petitions online that can be used to send that message. And it has to be generally specific, right? It can't just say, well, please promote immigration. You would, for instance, say, please make sure that USCIS doesn't end the H-4 EAD program, right? And our members use that program, and give some examples in the petition of people that use it, the harms that they would suffer if that program went away, right? And that's one thing you can do. The other thing is that, in the US, money talks in politics, right? I guess that's the same everywhere in the world, but definitely happens here. So you can do fundraising for particular candidates. And the estimates are that members of Congress spend 50% of their working hours on fundraising. That may come as a surprise. It surprised me, but that's a fact. It's 50% of their time is done reading bills and meeting with members of their constituents, things like that. And 50% is fundraising for the next election. So they spend a lot of time trying to get money so they can keep their jobs, right? And if you have the ability to collectively pool some money, you can donate to candidates. And you want to donate to a candidate that has any chance of implementing the policy that you want, right? Don't just give money to someone that's going to say, thanks for the money and I'm going to do what I want, and it's not going to help you, right? You want to donate to someone that can actually use it. And also you can strategically give money to particular candidates. So say you have a candidate that has no chance of losing, like say a Cory Booker in New Jersey, someone that's, good reputation, very strong funding. Maybe don't give him the money because it's not really doing, the impact of that dollar is not as much. Maybe you can give the money to someone that's in a swing state, someone that's in a very closely challenged election, right? Someone that can actually benefit from that money. So there's ways to strategically do fundraising as well, so that when if the person wins, then they'll say, okay, you gave me the money, you wanted me to make sure that I'm promoting immigration, I'm promoting the interests of the Indian community, and I'm going to do that. So again, money is a good way to get what you want done. The other thing is the court system actually. So IT Serve, you know, I've spoken at IT Serve events for years now, and you know, and I would every year I would tell them, you know, you're a very powerful organization. If you collect all the money that, you know, if you combine the total revenue of all the members of the IT Serve community, it's probably in the billions. You need to use that money and fight in court. And finally, after many years, they finally did that. And now you've seen the impact that it can have. Now, you can pursue a similar thing. You know, you can put together a legal defense fund. That's what a lot of organizations do, right? So basically pool some money from your members, use that to pay for key lawsuits. So say one of your members has a denial that is very unfair. You can use that money to fund for their lawyers, basically, to fight that kind of case. So a lot of organizations will have a legal defense fund that they'll pool money for. So yeah, it's really at all levels of government, fundraising, petitioning, and also at the court system as well.
Thank you. Thank you so much, Akshay. Usha, so I think we answered pretty much your questions we received on the registrations as well as on the live Zoom chat, and I think we covered pretty much all the questions. And thank you very much. But I would like to ask our secretary, Usha Darsipudi, to give the vote of thanks.
Thank you, Sridevi. Thank you, Mr. Akshat Tiwari, for the wonderful and informative session. Thanks for joining with us. And thank you for my team for making this happen. Thank you, Uma Makam Garu and Vasantana Garu for joining us. Thank you for the registrations, like the people who registered and asked the questions. And thanks for people watching on the YouTube. Thank you very much.
Okay, thank you again for having me on this call. It was enjoyable for me, and I look forward to doing this again with you soon.
Definitely, definitely. We will reach out, as well as the whoever attended today, if they need any like advice from you. So we will reach out to you through us. So it would be helpful for them as a community. You can, along with us, you can show them and answer some of their questions. So it will be very helpful.
Sure. Thank you.
Thank you, Akshat. I'll be in touch.
Thank you.
I'll contact you Monday. Yeah.
Take care.
Thank you.
Thank
Have a
you.
great weekend.